A bold statement has been made by the co-founder of Palestine Action, Huda Ammori, accusing government ministers of spreading false and defamatory claims. This comes as a response to the recent mass arrests and the government's attempt to justify them. The controversy began when 532 individuals, half of whom were aged 60 or older, were detained over the weekend under the Terrorism Act for allegedly showing support for Palestine Action. This has sparked a debate about the criminalization of peaceful protests and the treatment of older individuals. In a statement, a Downing Street spokesperson labeled Palestine Action as a violent organization, citing instances of violence, injury, and criminal damage. Home Secretary Yvette Cooper also claimed that Palestine Action is not a nonviolent group, adding that court restrictions limit public knowledge about the organization. However, Ammori strongly refutes these claims, stating that the government's own intelligence assessment, revealed in court, acknowledges that Palestine Action does not advocate for violence against persons. She highlights actions such as spraying red paint on warplanes and disrupting Elbit Systems, Israel's largest weapons manufacturer, as non-violent forms of protest. The Joint Terrorism Analysis Center, JTAC, a government body within MI5, produced a secret report on March 7th, which was disclosed in the High Court. While recommending the ban, JTAC described Palestine Action's tactics as primarily direct action, resulting in minor property damage. Common tactics include graffiti, vandalism, occupation, and lock-ons. Defend Our Juries, an organization supporting Palestine Action, has pointed out the Whitehall official's description of the ban as relatively novel, as there is no known precedent for an organization being banned solely for its use or threat of property damage. A spokesperson for Defend Our Juries expressed their outrage, stating that Yvette Cooper is actively misleading the British public about Palestine Action's nature, knowing that any defense of the group could result in lengthy prison sentences. The group has already received commitments from hundreds of people for the next protest, which is expected to be even larger, likely taking place in early September. The uncertainty surrounding charges and prosecutions remains. Tom Franklin, chief executive of the Magistrates Association, suggests that it may take days or even weeks to decide whether to charge those arrested, and many cases may be heard in the Crown Courts instead of magistrates' courts. Magistrates' courts typically handle less serious cases, but some charges under Section 13 of the Terrorism Act are either way, allowing defendants to choose their trial venue. The Defend Our Juries spokesperson believes that going to the Crown Court would be beneficial, as they feel the British public is more understanding of the issues surrounding the Gaza genocide and the government's support for it. However, they anticipate most charges to be laid under Section 13, which are all heard in the magistrates' courts, due to the criminal justice system's inability to manage such a large number of jury trials. This case raises important questions about the balance between freedom of expression and the government's response to protests. What are your thoughts on this matter? Feel free to share your opinions in the comments below.